Yes, sir.
The Controlled Substances Act is the legislation that results in the scheduling of drugs, right? And since 1992, I think Professor Michaud said the physicians in various states have had some kind of authority to recommend or the use of marijuana for individuals. Has the Drug Enforcement Agency thought about the rescheduling of the drug in the context of a variety of physicians throughout the nation recommending it contrary to the DEA's scheduling of it?
Professor Michaels, also Sam.
Yeah, I'll try to be quick. So there have been at least three instances over the last 20 years where the DEA has revisited the scheduling question. It has authority under the Controlled Substances Act to move marijuana to a different schedule. On each of those occasions, including just a few weeks ago, the DEA refused to move marijuana. And I think the main reason is that the main difference between the DEA's view of the drug and the state's, medical marijuana state's view of the drug, is that the DEA requires a different type of evidence. It doesn't want anecdotal evidence, doesn't want practices by physicians. It actually wants to see large-scale research studying the effects of this drug and demonstrating the medical benefits of this drug. And even though there's been a lot of research done on marijuana the last 20 years, a lot of reforms to state laws, there hasn't been anything that's done, any scientific research that's met the sort of gold standard that the DEA requires. So it's a constant refrain from the DEA. Show us studies, don't just show us anecdotes and practices from physicians.
Sam, you want to?
And yet was its placement upon the schedule based on a large-scale gold standard double-blind certain testing?
Go ahead, Sam.
I think the DEA has said that they have moved away from harm as a justification for Schedule I status and have focused on medical use. Just a couple very quick things. Rob mentioned we want sort of double-blind studies that show the benefits of marijuana. That's actually more possible now that the DEA has said that they will make marijuana, they will increase the number of licenses for people that want to grow marijuana for the purposes of engaging in that. Furthermore, I'll say that the refusal of the DEA to reschedule marijuana has consistently been upheld by appellate courts that have looked at it, whether it's in D.C. or in the Ninth Circuit. And the final thing, it was a small point, but you said since 1992, physicians have had the opportunity to recommend marijuana to their patients. That opportunity actually comes from the First Amendment and not from the act of any state, and that's what the Ninth Circuit held in the Conant decision was that a physician cannot be precluded from recommending what she believes is a beneficial course of action to her client.
Hi everybody, my name is Mike. This is my YouTube page, Mox News. Thanks for tuning in. Okay, so first let me say, fuck the DEA. Okay, this is a bunch of bullshit. Well, let me say first, the real reason isn't because of the First Amendment that physicians are allowed to prescribe the real reason is because of the Second Amendment. Because the only reason you still have a First Amendment is because you have the Second Amendment. And that's the facts. These people, oh, we're not here to take your guns, we're not here to take your rights. Of course they are. Every chance they get, they take away our rights. Okay? The facts are, the DEA doesn't want some giant study that proves that marijuana is whatever. The DEA knows exactly what marijuana is. The DEA knows marijuana has tremendous medical qualities that the guy at the beginning says human beings have been using cannabis for 10,000 years. I personally believe it's probably closer to 20,000 years. Possibly more. But I'd say 1,000 generations, which is 20,000 years, human beings. And they've been using it for 20 1,000 years as a medicine up until 1917, when it became this racist thing that they could impose on black people and Mexicans, brown people. We all know this. The DEA doesn't want some big study that says, oh, no, it's beneficial to humans to use marijuana. What the DEA wants is the money that comes from prosecuting marijuana, cannabis, from cannabis being illegal, gets them, what, $20 billion a year to run their fucking police state propaganda, war on drugs bullshit. The war on drugs is the gateway, okay? There is an heroin epidemic in this country. That's what we keep hearing. Every single politician during this election season has said there is an opioid heroin epidemic in this country. How long has the war on drugs been going on? That's what it has brought you. An epidemic of heroin use. The war on drugs is the gateway. The DEA is the gateway. And they will not ever admit it because they make money off of it. Hand over fist. Oh, the courts have upheld the DEA. Right. The courts make money off of it. Off marijuana, cannabis being illegal. It is a crime against humanity. Right at the beginning of the Bible, it says, I give you this plant to use as meat. To use as meat. Right at the beginning of the Bible, it says that. That's who you DEA scum are. I bet you 95% of the scumbags in the fucking DEA claim Christianity. But you don't believe in God one little bit. You go out and destroy children's lives. Oh, we got to protect. We have to think of the children. They go out and destroy children's lives by keeping this plant illegal. It destroys their future. They destroy families. They destroy marriages. They destroy thousands and thousands of Americans' lives on a daily basis by keeping this drug illegal. Thousands, how many people are addicted to heroin because of the drug war? Because they have to hide their use of this incredible, dangerous drug. Which, again, I showed you on my last video. States that have marijuana legal have 25% less opioid overdoses per capita. That simple. The drug war is the gateway to the heroin epidemic. You want to make it right, end the drug war, get rid of these dinosaur prosecutors. Because why are they having to keep the drug laws in place? Why do they need to? We got to protect the children. No, we got to get that sweet, sweet fucking drug war profiteering money. We have to have this power over the people to make them have to hide in their homes, to be able to kick their door open at their home because we smell marijuana. How many thousands of times do you think that's happened in this country? Because we smell marijuana. You're fucking scum. Every single one of you that ever busted anybody for marijuana, you're fucking scum. The children of this country will be safer when you burn in fucking hell, you fucking scum. Got it, DEA? Do you hear me, DEA? And you know whose fault it really is? Is Obama. Obama promised change. Obama stood there and said, I'm not like these other presidents. Look at me. Do I look like the other presidents? I'm not like them. I understand your hardships. And he militarized the fucking local police, your fucking scumbag local police, he militarized them more than George Bush and every other president before them. He made them ready for martial law. That's who Obama was. And as soon as he's burning in hell, the children of the world will be safer. And that's the fucking fact. And the reason you have Donald Trump right now on the edge of becoming the next president of the United States is because of Obama. Because Obama stood there and said, I promise you change. I'm giving you the hope of real change. Just support me and I will show you real change in this country. And he turned his back on the American people. And he clearly doesn't give a fuck about black people, because if he did, he would have done something about these marijuana laws immediately upon entering office. Because he knows the truth. He smoked marijuana all throughout high school. He was known as a stoner, party boy. He's just lucky he didn't have his life ruined by some scumbag fucking pig who was having a bad day and ruined your life because he could. I'm sorry, I'm not feeling very good today. I still have my damn cold. I can't get it out of my lungs. I'm up and around. The fever's broke. Got a headache today that I'm having trouble getting rid of. But I got this shit in my lungs. I haven't been able to have a puff for 10 days. Because I won't smoke. If there's anything going on with my lungs, I won't smoke. Because I don't want to force it deeper in my lungs. I just want it to go away so I can go and have a puff. Anyways, tomorrow's the election. 5 states are ready to legalize marijuana, cannabis, for recreational use. I hope you do it. I hope you do it. I hope you guys believe in freedom enough to do it, to take power back from the police state. So, anyways, I need to say that. Thanks very much for tuning in. My name's Mike. This is my YouTube page, Mox News. Stay cool. One of these days, this drug war is going to end. The war on the people. The war on your children. The gateway to their heroin use. One of these days, this war is going to end. You fucking DEA scumbags that are at war with the people. One of these days, this war is going to end. One way or another. Stay cool till that day.
Now a look at efforts by Colorado and other states to decriminalize the use of marijuana. From the 10th Circuit Judicial Conference, this is 90 Minutes.
But I'm really pleased to have a chance to introduce you to our next session, which is current and emerging issues of legalized marijuana. And when I was thinking about this panel last night, I said, what in the world am I doing here moderating a panel on marijuana? I think my wife said that, Tim, you probably drew the short end of the joint. Grown. And just to clarify things, unlike our mindfulness session that we had yesterday, this will not be an interactive session. Okay? It's undeniable over the last decade we have witnessed a tremendous shift in the legalization of marijuana in various forms among the states. As of today, 4 states, Colorado, Washington, Oregon, and Alaska, and the District of Columbia have legalized the recreational use of marijuana. And another 25 states permit medical marijuana or have decriminalized marijuana possession. Indeed, as a testament of the timeliness of this session, voters in at least 9 states will decide the various measures of legalization this November. Arizona, California, Maine, Massachusetts, and Nevada are considering legalizing the recreational of marijuana as well. Arkansas, Florida, Montana, and North Dakota are considering medical marijuana. But our fascination with marijuana is no new phenomenon. Marijuana's existence dates back over 10,000 years and came to the United States before the American Revolution. In fact, early revolutionaries actively grew various strains of cannabis, mostly for mass hemp production. Closer to home, at the time Colorado became a state in 1876, both hemp and marijuana were legal and had multiple uses. But in 1917, as part of a growing movement, Colorado criminalized the use of marijuana as a misdemeanor and later made it a felony. That situation lasted for 40 years, and nobody over the age of 60 here knows that the use of marijuana hit its stride in the late 1960s, especially on our college campuses. Now, I'm only 59 and a half, so I'm not sure what we're talking about here. In 1970, recreational possession was downgraded in Colorado to a misdemeanor, and in 1975 we made possession and private use of less than an ounce a petty offense. As for the legalization movement, Colorado's been a leader in the United States. In the late 1970s and early 1980s, Colorado passed several measures to legalize medical marijuana, but those efforts never got off the ground due to federal law classifying marijuana as a Schedule I controlled substance in 1970. That brings us to the current state of the law in Colorado. In 2000, Colorado passed Amendment 20, which amended the state constitution to allow for the medical use of marijuana. And then in November 2012, Coloradans approved Amendment 64, making Colorado, along with Washington, one of the first states in the union to legalize the recreational use of marijuana. Now for a few quick statistics. In 2015, marijuana sales in Colorado came in at nearly $1 billion, which is up from nearly $700 million in 2014. I'm sure our panelists will comment, but I think we're on track for a $2 billion in sales this year. That's produced over $135 million in tax revenues so far. Currently, there are 698 marijuana dispensaries or storefronts in Colorado. To put that number in perspective, that's more than the number of McDonald's, Starbucks, and 7-Elevens combined. Notably, legalization is an opt-in policy, meaning that individual cities can decide or not to allow or not allow marijuana businesses in their city limits. Of the 321 jurisdictions in Colorado, 71% have already banned medical or recreational marijuana businesses. So with that brief overview, I'd like to recognize our very distinguished panel of speakers. Importantly, our panel members represent both academia and the bar, so I hope you can walk away from both a theoretical and a practical understanding of their experiences. Our first speaker is Professor Robert Michos. Professor Michos is law professor at Vanderbilt University, where he teaches constitutional law, federalism, and marijuana law and policy. Professor Michos is a leading expert on marijuana law and policy and has written, testified, and lectured specifically on states' constitutional authority to legalize marijuana, federal preemption, and state marijuana reforms. And he's in the process of completing a textbook on marijuana law and policy to be published later this year. And I know up at my alma mater, his textbook will probably be in the classroom next fall. Professor Michos is a former clerk to Chief Judge Michael Bodan in the First Circuit, and we welcome him here. Our second speaker is well known to you Coloradans, Professor Sam Kamen. Professor Kamen is the Vicente Cederberg Professor of Marijuana Law and Policy at the University of Denver Sturm College of Law. Professor Kamen is an expert on marijuana law reform and was a member of the Colorado Governor's Amendment 64 Implementation Task Force. He's published over a dozen scholarly articles on the subject of marijuana law, law reform, and co-authors the series Altered States Inside Colorado's Marijuana Economy for Slate magazine. Our next speaker is General Pete Michel. General Michel is the Attorney General of the state of Wyoming. Prior to becoming Attorney General, he was the Chief Deputy Attorney General and was also the Senior Assistant Attorney General supervising the water law section of the Natural Resources Division of the Wyoming Attorney General's office. And he succeeded our own Greg Phillips, who was the Wyoming Attorney General before that. And continuing the law clerk trend, Mr. Michel was a clerk for Justice Joseph Cardine in the Wyoming Supreme Court. Our next speaker is a special introduction for me. It's Fred Yarger. Fred is the Solicitor General of the state of Colorado, and this is a treat because he's one of my former clerks. As Solicitor General, Fred supervises and determines the legal strategy for appeals as well as select constitutional litigation. Before becoming Solicitor General, Fred was the Assistant Solicitor General and worked at Gibson Dunn in Denver. He's a graduate of Dartmouth College and the University of Chicago Law School. In addition to clerking for me, Fred clerked for Judge Mark Phillip in the U.S. District Court for the Northern District of Illinois. And I might add that Fred has a rare treat this year. In addition to speaking at his first bench and bar conference, Fred has an argument in the U.S. Supreme Court coming up in October. Good luck, Fred. Our next speaker is Methan Mansinghani, who is the Deputy Solicitor General in Oklahoma. That means he litigates appeals and constitutional issues on behalf of the state. Prior to joining the Oklahoma Attorney General's office, Mr. Mansinghani worked for Gibson Dunn in Washington, specializing in appeals and administrative law cases. He's a former clerk to Judge Jerry Smith on the Fifth Circuit, and we welcome your attendance today. With those introductions, let's get started with Professor Mikos.
Thank you, Judge, for that kind introduction. And thank you to the conference for inviting me out here. It's quite a privilege. There is a rich and fascinating body of state marijuana laws that's developed over the last 20 years. And I think to understand these laws, we need to understand the constraints that have been imposed on the states by the federal government. Because many features of state law are really quite peculiar. And they really represent efforts by the states to work around those federal constraints, what I call workarounds. I'm going to talk about 3 examples of these workarounds to help illustrate the point, and then I want to briefly discuss why at least some of these workarounds may be problematic from both a federal and a state perspective. But before doing that, I want to give you a very quick overview of what the states have been doing over the last 20 years. And this is really the 20,000-foot view, or since we're in Colorado Springs, maybe it's a 25,000-foot view of the last 20 years of state marijuana reforms. This all started back in 1996, these modern reforms, with California's passage, there on the left-hand side of the chart, California's passage of Proposition 215, which is what I call a medical marijuana law. That was a law that permitted some people to use marijuana for medical purposes. That particular type of reform proliferated across other states in the ensuing years. As depicted in the chart, you see that red bar growing. The red bar represents, the red portion of that bar, that column represents those medical marijuana states, those states with medical marijuana reforms. It progressed steadily, picked up a bit in 2009, 2010, and then you also saw new reforms emerge as well. Perhaps most notably here in Colorado and in Washington State in 2012, those 2 states started to allow people to use marijuana for recreational purposes as well, or really any purpose they might have wanted. Those state reforms are represented in green up on the graph. And then in 2014, it's also noteworthy that you saw a number of more maybe conservative states jump into the fray. They were reluctant to legalize even medical marijuana, but these states did legalize CBD, which is one chemical found in the marijuana plant. They legalize it for certain medical purposes. They're represented up there in black because it's a little hard to tell them really from the prohibition states. But one remarkable thing that you see on this chart up there is that as of today, as of 2016, we have 43 states that allow some people to use marijuana legally. In other words, they've gone beyond mere decriminalization. They allow certain people to use and possess the drug legally. Even though throughout this entire period, the content of federal law has remained unchanged. Of course, federal law bans the use and possession of marijuana. But I want to suggest to you that the states have found ways to work around federal obstacles. And let me give you 3 examples of that. So the first, the states found ways to get doctors to help police the medical use of marijuana. without exposing those doctors to federal sanctions. And this was absolutely critical in those early days of reforms, critical for the medical marijuana states that wanted to limit access to the drug. In other words, they wanted to allow people to use it for medical purposes, but they didn't want it being diverted to non-medical purposes. And for other drugs, for other controlled substances, states commonly use physicians as gatekeepers. For example, if you want to go out and get Percocet, which is a controlled substance, an opioid painkiller, you need a doctor's prescription. You can't just walk into a Walgreens or a CVS to buy it. But the states couldn't do that for marijuana. And that's because the federal DEA says that physicians can't prescribe this particular drug. They can't prescribe any drug that is on Schedule 1 of the Federal Controlled Substances Act. If they do, the DEA has threatened to yank their authority to prescribe other drugs. In other words, the DEA will yank their registration to prescribe controlled substances. So any state medical marijuana program that required a physician to issue a prescription for marijuana would be a non-starter, because no physician is going to risk their registration with the DEA, their medical practice, their livelihood in order to prescribe marijuana. In fact, the states already knew this when California passed Proposition 215 back in 1996. I put up here an example of a law that was passed almost 2 decades prior to California's medical marijuana law. This one was actually passed in Virginia in 1979. It's a law, a medical marijuana law, that allows people to possess and use marijuana free of state sanction so long as they get a physician's prescription to use the drug. But laws like this, like Virginia's law from 1979, didn't have any effect. No physician was willing to follow through and issue a prescription, so they were really nullities. They're still on the books in those states, but they didn't have any practical effect. But California, at least the proponents of Proposition 15, found a workaround. And what was that? Well, Proposition 215 only required a physician to recommend, not to prescribe marijuana. Now that may seem like semantics, like the state was simply playing word games, and that was the DEA's position, but California later convinced the Ninth Circuit that it made a difference. That in fact, when a doctor simply recommends marijuana, and all that entails is having a conversation with a patient where you declare you might benefit from the use of marijuana, the Ninth Circuit declared that that was protected speech under the First Amendment. And as a practical matter, that meant that the DEA couldn't punish doctors for issuing a recommendation, even though it could punish them for issuing a prescription. So every state following California's adoption of Proposition 15, every other state that adopted a medical marijuana law has followed California's path and now requires only a recommendation. They call it different things, a written certification and so on. They do not require a prescription. A second way that the states have worked around federal law, the states have found ways to diffuse the threat of federal crackdowns on marijuana supply. State marijuana reforms would really be hollow if people couldn't actually get marijuana. It's like me telling my 5-year-old son, you can have an alligator as a pet. You can buy it the next time we go to PetSmart. You know, he's going to be happy with me. He's going to be very happy that I've allowed him to get an alligator as a pet. He's going to be sorely disappointed and probably mad at PetSmart when they discovers they don't offer one. In the past 20 years, the states have tried to provide marijuana in 2 basic ways, or at least provide 2 basic ways for people to legally obtain marijuana under state law. One is to grow it themselves, something I call personal cultivation. That is normally considered under most states to be a trafficking offense. But these states said you can grow it yourself. Another way is the commercial model, where states said you can go and buy this drug from some commercial operation, like a big shop out there that you see in Colorado today. And today, in fact, the states have mixed and matched these 2 different forms of supply. Their regulations employ one or the other of these 2 models, and they can basically fall into, we can typecast state regulations into one of 4 different types. One is that there are some states that allow you to get marijuana, but only if you grow it yourself or if you have a caregiver do it. Now, this is becoming increasingly rare. I think Michigan may be one of the few states that still follows this particular route, but the only way to get it is to grow it yourself. You can't buy it from a store. There's no commercial operations. Second model the states have followed, you only have commercial operations. You can't grow it yourself. You have to buy it from some big, highly regulated shop. A third model is similar to the one here in Colorado. It's a mixed supply model. You can grow it yourself if you want, or you can go into one of the hundreds of dispensaries that are now in operation across the state. And there's a fourth model out there employed by a couple of states that really is quite similar to the second one. It's where they prefer commercial cultivation. Arizona, Massachusetts are two examples of this. In these states, they say, go to a store to buy marijuana. We normally don't want you to grow it, but if a store is too far away from your house, you can go ahead and grow it yourself, if there's a hardship, in other words. Now, this next graph depicts the popularity of these four regulatory models over time. The red on this particular chart depicts those states that had the personal cultivation only. In other words, if you wanted marijuana, you had to grow it yourself. Blue depicts the states that say you can only get it from a big store. Purple is a combination of those two things, appropriately enough. You can choose to get it from a store or to grow it yourself. And the bluish color right under the solid blue there, the middle one, are the states that prefer commercial cultivation but make some exception for personal cultivation. As you can see from this chart, in those early days of reforms, it feels weird to think of 1996 as early days or long ago, but personal cultivation was the only game in town. In other words, states were exclusively or almost exclusively red. There were shops that were operating in California and elsewhere, but those shops were still considered illegal under state law, at least until 2003, when a couple states started experimenting with this. But it was really only until around 2009 that states really started to embrace that commercial distribution model. In other words, creating these or allowing these commercial stores to sell marijuana. Those early states, those early adopters that were in red, turned purple. They allowed people to grow it themselves, but now started to allow people to buy it from stores. And interestingly, every state that has passed a marijuana reform since 2009, every single one of those states is a blue state, or one of those mixed blue states. That is, they want you to go to a store to buy it, rather than to grow it yourself. So why the early reluctance to embrace commercial cultivation, and why the sudden shift to commercial cultivation in other states in 2009? Well, it goes back to federal enforcement. Those large-scale commercial suppliers are much more vulnerable targets to federal enforcers than are the little guy, the person who's growing a handful of plants in their basement for their own needs or for the needs of someone they're taking care of. And in the early days, the federal government was both willing and able to try to shut down those large commercial suppliers, but it simply couldn't arrest the little guy. It couldn't go after individual patients and caregivers growing only a small number of plants because there were far too many of them, hundreds and hundreds of thousands in the states. So the states that were early adopters that knew that the federal government would crack down on commercial supply, those states embraced personal cultivation, at least in part because it was the only way that they could ensure that qualified patients would actually have a supply of marijuana that wouldn't be interrupted by the federal government. But in 2009, of course, you see this big shift. Well, that's when federal enforcement priorities started to change in federal enforcement practices. That was the first year that the Department of Justice issued one of its enforcement memoranda. This one was called the Ogden Memoranda. And although the Ogden Memoranda was quite cautious, if you actually read it, many people perceived it as essentially giving the green light to commercial cultivation, as essentially the federal government saying it's okay to set up these stores that will sell marijuana to patients. That helped spur this dramatic shift in state law. And that's why states started to legalize commercial cultivation following the issuance of the Ogden Memoranda. And you saw, of course, state licensed stores proliferating. This is a map of Colorado. The green dots represent state licensed stores, stores that are licensed by the state to sell marijuana circa 2004. There are even more on the map if I had a more recent map today. There are actually hundreds of these state licensed shops in Colorado and in other states as well. But even as this commercial supply has caught on, there's something that the states haven't done that seems a little surprising. But again, it seems surprising only until you consider federal law. Let me give you my final example here. Where are the state-run marijuana stores? To this day, no state has directly owned and operated a marijuana store, a commercial marijuana store. This is surprising to me in light of the state experience following the repeal of alcohol prohibition. When the states repealed alcohol prohibition, many of them decided to own and operate a piece of the alcohol distribution market. They thought of this as a way to curb illegal sales of alcohol and also a way to curb the natural inclination of private for-profit enterprises to grow their market. Now, that model has lost some popularity today, but even today, about a third of the states continue to directly control some aspect of alcohol distribution. This is, I think, a state alcohol store in New Hampshire that's depicted up there. So why haven't any states done this for marijuana? In other words, why aren't there any state-owned and operated marijuana stores? And this is an instance where the states haven't been able to work around federal law. And in particular, they haven't been able to work around preemption concerns. So if a state were to own and operate a marijuana distribution center, a marijuana store, it's arguable that someone could come up, file a lawsuit arguing that the state operation was preempted and get an injunction to block its operation. The same thing couldn't necessarily be done with a private licensee, because a private licensee, a licensee of the state, isn't necessarily a state actor. Now, as you'll hear later, there might be suits that are brought against state regulations, the licensing regulations, the regulations of that private actor. But even if you eliminate those regulations, it doesn't stop that person from operating the store. They may just do so free and clear of any state restrictions. So even if these preemption concerns are out there, they're much more salient for state-owned and operated stores. I think they're the reason why the states haven't gotten into this particular business. Now, let me briefly conclude and give my thoughts on whether this is a good thing. I think these three examples show how federal law has influenced the development of state law. But in a large way, they've really distorted the development of state law. And I think for the last 20 years, the federal government has really been playing a high-risk strategy. In other words, the federal government was betting that the states wouldn't be willing to repeal their own prohibitions or scale back prohibition if they couldn't get doctors to issue prescriptions and use the prescription monitoring programs that they had, if they couldn't go out there and create these large, tightly regulated commercial operations. And the federal government got it wrong. The states were willing to do that, but the result that we have is less than ideal, both from the perspective of the states and from the federal government. What we end up with is a system that isn't quite one that any state in isolation, if left to its own devices, would necessarily adopt. Let me give you the example to go back to the example of personal cultivation. That was hardly the ideal model for the states in the early years. To say to a 70-year-old cancer patient, you can use marijuana legally, just grow it yourself. Not everyone has that sort of green thumb or access to friends, even in California, who know how to grow and distribute marijuana. So from their perspective, it didn't serve patients to adopt the personal cultivation model. And even from the federal government's perspective, this wasn't necessarily the model you would want the states to choose, because the states chose it to evade federal law enforcement. They knew that the federal government couldn't crack down on these personal cultivation operations. But at the same time, for the same reasons that it was tough for the federal government to stop those personal cultivation operations, it was also tough for the states to supervise them. Very difficult for the states to go out there and monitor the 50,000 or 100,000 patients who may be growing a few plants in their basement to make sure that they're not selling a little bit on the side or that they're not using it recreationally and so on. So ultimately, I think this example of marijuana just tries to show how a hardball strategy or a take no prisoner strategy like that pursued by the federal government, at least in the early days, isn't one that necessarily works out well for either party in the end.
Great, thank you so much, and thank you, Judge, for the invitation, and thanks to the organizers. I'm thrilled to be here and to talk with all of you about this important issue. I'm sort of going to take over from Rob here and talk about what I call the stalemate over marijuana law. Rob has sort of, I think, very ably given us a sense of how we got to this place. And I want to talk about where we are now and what the implications of that are, particularly going into the election in 2016 and policy making in 2017 and beyond. Rob mentioned the 2009 Ogden memo. This was replaced in 2011 by another more cautionary memo from the Department of Justice. And finally, in 2013, we have the memo that we're all living under today, which most people refer to as the Cole Memorandum. This memorandum stated the obvious, as Rob pointed out, that the state governments do most of the work of drug law enforcement in this country, that while the federal government prohibits marijuana and continues to prohibit marijuana, the states are really the foot soldiers in the war on drugs. And stated that marijuana should really be no different from that, even as states experiment with alternatives to prohibition. The Cole Memo in 2013 voiced deference to the states, a willingness to let the states engage in the experiments that Rob described, so long as certain federal criteria were met. It set forth 8 federal criteria. The principal one, and one I'm sure our friends to the north and east will have something to say about shortly, is diversion of marijuana from states where it's authorized by state law to states where it is not. Another is the sale of marijuana to minors. Other things such as the involvement of organized crime, of other drugs, of guns in the distribution of marijuana were all prohibited. But the Cole Memo said so long as the federal government, or sorry, excuse me, so long as state governments are doing a good job along these 8 metrics, the federal government would defer to that policymaking choice. Other memoranda from the Department of Treasury, the FinCEN Financial Crimes memo, which was purported to encourage banking, the separate memorandum on the capacity of Indian tribes and nations to produce and sell marijuana, and private statements by both President Obama and Attorney General Holder, we're all in the same direction. That is, we see what the states are doing. We see how this is now the view of a strong plurality of states moving, depending on how you count, to either a majority or a supermajority of states. And we're going to see how that experiment plays out. So it's really important to state, and the Cole Memo stated, that marijuana is still prohibited by federal law, that this is an enforcement priority that is being stated in the Cole Memorandum, and it does not have the force of law. This is not the legalization of marijuana. It's simply a matter of enforcement. This was written into law, this forbearance was written into law, albeit in a slightly obscure way, through the enactment of the Rohrabacher-Farr amendments to various federal spending provisions. Now, if you haven't heard about these, don't beat yourself up. This was paragraph 542 of a very long spending bill that was enacted by Congress both in 2014 and 2015, which stated that none of the funds made available in this act to the Department of Justice may be used with respect to, and it listed at the time 34 different states, to prevent such states from implementing their own state laws that authorize the use, distribution, possession, or cultivation of medical marijuana. That is, we are not authorized, or the funds that are authorized by Congress may not be used by justice to prevent such states from implementing their own state laws. Okay? That's the language of the statute. It was a number of criminal defendants in California and elsewhere, said that this meant that the Justice Department was now prohibited from enforcing criminal marijuana laws in those states where that conduct was authorized by state medical laws. Okay? That they took this Section 542 as a prohibition on prosecution, and just 3 weeks ago now, the Ninth Circuit Court of Appeals, sitting again in California, agreed. It said, we conclude that at a minimum, Section 542 prohibits the Department of Justice from spending funds from relevant appropriation acts for the prosecution of individuals who engaged in conduct permitted by state medical marijuana laws and who fully complied with such laws. This is amazing, right? This says that if you are acting in accord with state law, you may not be prosecuted under federal law. It also creates some odd circumstances where in a federal prosecution it becomes quite relevant whether you were in compliance with state law. There are some examples of federal courts doing that kind of determination, but I think this will lead to quite a bit of litigation over who exactly is in accord with state law and what state laws will count. If a state were to say, well, we think all use of marijuana is medical use, does that mean that all people are thus insulated from federal prosecution? Even if it were to mean that, and you know, it's too soon to know exactly what that means, what we have now is really a truce and not a peace between the state and federal governments. And I say that because, as the Cole memo made clear, and as the McIntosh decision from the Ninth Circuit did not disturb, marijuana remains illegal under federal law, and I hope that any lawyer who speaks to any client on any legal matter concerning marijuana, those are the first words out of his or her mouth. Marijuana remains illegal under federal law, and the reason it's so important to state that, even if the Justice Department has said it won't be prosecuting and the Ninth Circuit has now said that it can't, there are lots of what I call collateral consequences of marijuana's continuing federal illegality. The probably best known of these is the banking problem, that despite the FinCEN memo, no bank will consistently or for long bank the marijuana industry. That means that in Colorado last year, marijuana was a $1 billion cash business. That is a spectacularly bad idea. It's a bad idea for the people in that business who have to pay their employees in cash. It is a bad news for those employees who have to go home with their paychecks in cash. But more than that, it is bad news for state regulators, because if one of the things that the federal government has charged the states with is keeping organized crime out, and if one of the things that regulators are trying to do is to regulate and tax marijuana, a cash business is incredibly hard to regulate. There is no paper trail. We're talking literally about bags full of cash. That hampers lots of different state goals, as well as putting citizens at risk. Taxation is another issue that is hampered by the continuing federal prohibition. If you are in the business of violating the Controlled Substances Act, Rule 280E makes all deductions except the cost of goods sold unavailable. That makes the effective tax rate for a lot of marijuana businesses something north of 70%. It also creates perverse incentives for the marijuana industry, that if they have some revenue, the only way they can protect it from cash is to turn it into cost of goods, that is, to make more. And the only deduction they can get is if they increase their cost of goods sold by producing more marijuana. Again, that may not be the best public policy outcome. Contract is another one that, you know, we normally think of businesses as relying on the use of contracts in their enforcement. That has been a mixed reality in the time since states have begun legalizing marijuana. I always teach the hammer against today's healthcare, THC, case out of Arizona. A really great one for any first-year contracts class. The two Arizona individuals had lent money to a Colorado dispensary. The Colorado dispensary stopped paying, and the Arizona individuals sued in Arizona state court, thinking this is great, we're going to get home field advantage on these nasty Colorado drug dealers. The Colorado dispensary showed up in Arizona state court, and of course they said, Your Honor, this contract's unenforceable, we're drug dealers. And they knew very well that we were drug dealers when they lent us the money. And the judge said, go and sin no more. You do not have to repay this. You do not have to repay this contract. This contract is void on public policy grounds. And while that may at the time have seemed like a win for the marijuana industry, the unwillingness of people to pay their debts probably is not the best thing for the growth of an emerging industry. I've also listed here a great case, the Green Earth Wellness versus Attain Specialty Insurance case that Judge Krieger had here in the District of Colorado. The Green Earth Wellness had some crops damaged by smoke in a big fire here in the Springs, and they brought a claim under their insurance policy which covered growing crops but had an exclusion for contraband. It's a sort of another classic statutory interpretation question like we heard about in our last panel. Well, what do we do with this contract? And Judge Krieger, I think correctly, said, did you know what you were insuring when you took their premiums? If you knew you were insuring marijuana, I don't see why you shouldn't have to pay out on this claim. And in doing so, said some things in passing that were quite remarkable. She said, well, why do we think that the federal government has a strong public policy against marijuana? Sure, it's still illegal, but they don't seem to be acting like it's illegal. And there's lots of language in there to indicate her view that marijuana now has a quasi-legal status under federal law. The Arenas case made clear that bankruptcy protections are not available to marijuana businesses, even though debts that they hold can be erased in bankruptcy if the person holding them can gain access to the bankruptcy courts. Those in the marijuana business cannot. Finally, in terms of employment, we saw the Coates case that was handled by our Colorado Supreme Court, where the court unanimously determined that Mr. Coates, who was a medical marijuana user in compliance with state law, could nonetheless be fired under our state's lawful off-duty conduct policy because he was violating federal law. That even though his conduct was clearly sincere medical use, it was not lawful conduct because his conduct continued to be prohibited by federal law. In closing, I'll just say a few words about something that could be of interest to many here, which is access to law and lawyers. Every state has some version of Model Rule of Professional Conduct 1.2d, which states that a lawyer shall not engage counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. Well, while all marijuana conduct remains illegal under federal law, a clear question arises about whether a lawyer may do anything to facilitate that conduct, right? If that's criminal conduct and the lawyer knows that's criminal conduct, a plain reading of 1.2d seems to say that the lawyer may not assist in any way. The Colorado Supreme Court, in a comment to our rule paralleling 1.2d, stated that this does not preclude an attorney from assisting conduct permitted under state law, and most states have agreed, but the District of Colorado has not. That is, while adopting all or nearly all of the Colorado ethics rules, the district court did not adopt that comment. Attorneys may counsel regarding the meaning of Colorado state law, but they may not assist a client even in conduct that the lawyer reasonably believes is permitted by such laws. I could give more examples. I could go into depth on all of these. I want to get to our other panelists, so I'd be happy to take any questions that you have when we're done. Thank you.
Thank you. General Michael?
Thank you, Judge. It's great to be here. Last time I was at the Broadmoor, was 3 years ago. I was at a conference of Western Attorneys General, and I got the phone call from the governor to be acting Attorney General, and it's been a very fast-paced 3 years since then. That was when Judge Phillips was confirmed by the U.S. Senate to be 10th Circuit Judge, and I stepped up from his Chief Deputy spot to be Attorney General. And I've learned, it turns out the Wyoming Attorney General also has an appointment immediately called Commissioner of Drugs and Substance Abuse, so I'm in charge of that, I guess. And I've learned a few things in 3 years. But I thought, you know, one thing I've learned is that this marijuana debate is people are very vocal. They have very strong opinions. We have Governor Meade, who was a former United States attorney, had a panel. I was on a committee that we produced a very lengthy report earlier this year on the possibility of legalization in Wyoming. I'll talk in a minute about a little bit of legalization that we have. It's very tiny, but we had a committee, and of course we had open public forums, and some of the folks would come in and speak, and they were very, very adamant about their views on marijuana one way or the other. So it's a very very strongly, people have very strongly held beliefs. And one of the things I thought I would do before I talk about some of the things I see more from a law enforcement perspective, maybe from a scientific perspective, a crime lab perspective, is just give you a little idea of where I'm coming from. I think people in this debate actually ought to identify a little bit their background, where they're coming from, because everybody gets a chance to, should have a chance to see us, see what our biases are as we come into a debate that's so highly charged as this one is. Let me just go through the things that I see on a daily basis that kind of give me some of my perspectives. One of the things I do as the Commissioner of Controlled Substances is I recommend scheduling of new substances. That's the easy one. The federal government will identify a brand new molecule that's been developed by drug synthesizers, and they ask the state to adopt that, and we adopt that as an illegal substance. The other thing I do, and this is very controversial right now, but it does give me a little insight into what's happening out there in the drug trade, is in Wyoming we have asset forfeitures like most states do. That's been a very hot topic over the last several years, and we've had some amendments to our laws. One of the things that I do is I actually approve, I get phone calls in the middle of the night, sometimes the middle of the day, approving a seizure of guns, money, mostly money, from people that are trafficking drugs. And that's not the drugs themselves, these are people that are transporting money across Wyoming. And that's something, I get a pretty good view of kind of what's going on. I had a call yesterday, I had one the day before. I probably get 20, 25 in a year, where I'm asked to approve probable cause for the seizure of assets from what are believed to be drug traffickers. That's just the beginning of the process. It's a long process to actually forfeit those assets for drug trafficking. Another thing that I do is that the Wyoming Attorney General's Office does all of our criminal appeals. We have one set of appeals just to the Wyoming Supreme Court, being a small state in the union, but so I'm in charge of our attorneys that do the criminal appeals, and I'm very heavily involved. So I see what's happening in the drug trade in terms of the cases. Mostly they're felonies. The appeals are generally felonies, and I'm seeing who's being convicted, what they're doing, what kind of conduct, and what some of the things that are happening, what kind of criminal issues are coming through to the appellate court. A big one that I do is within the Wyoming Attorney General's office is the Division of Criminal Investigation. So our office has 260 folks, but over 100 of them are in the Division of Criminal Investigation. And that includes the operations division of that group, and what they do, it mostly is drugs, wiretaps, investigations, all the things that are done statewide on drug investigations is our Division of Criminal Investigation. And with that division, we also have a crime lab. And hopefully I'll have the time. I want to spend a few minutes talking about some challenges, scientific challenges we're having in the crime lab with marijuana. I get to see that up close, the difficult issues there, including trying to fund the kind of things we need to have a good crime lab to do the things that need to be done in this area. All of these would be affected or are affected by legalization. Whether Wyoming legalizes, but even Colorado's legalization affects all of these operations. One thing that I don't do, so I can't really comment too much about this, is in Wyoming, the Attorney General is not in charge of criminal prosecutions at the local level. We have elected county prosecutors. So most of the drug, it was mentioned earlier, most of the drug enforcement, Professor Michaels mentioned it, most of the drug enforcement in the United States is done by states. But in Wyoming, because the Attorney General's office does not run the local prosecutions, we don't actually engage in those prosecutions until they come up on appeal. And then we deal with the appeals. So I really don't do a lot of that, and I don't have a history, unlike General Phillips before me, or Judge Phillips. He was a assistant United States attorney and had prosecutorial experience, which I don't have. But I get a pretty good viewpoint and see what's going on out there in the drug trade, and we keep statistics. One final thing I'll mention that I do is, in order to get wiretaps for our investigations, I have to review those personally. And so Judge Rankin, for example, receives wiretap applications as his role as a federal magistrate judge. And also our local judges in Wyoming receive wiretap applications. Obviously, we have to have very strong probable cause before we're listening to people's conversations or on the telephone. So That's something that I personally do. So I get a pretty good handle on what's going on around the state of Wyoming in our investigations. Now, of course, Wyoming is one of those square states, as Justice Kagan mentioned, and it's the square state, the old joke, some of you aren't from Wyoming, so you haven't heard this. If you're from Wyoming, you've already heard this joke, which is Wyoming is a small town with really long streets. You know, we only have 600,000 or so people, and so a lot of the statistics and things that we see, you know, are a little different than what you see in larger areas that have larger metropolitan areas, but I think some of them are worth maybe hearkening to or paying attention to. One thing I want to mention briefly, and then I'll move on a little bit to my general observations about where I think things are heading, some of the challenges that we're facing in the law enforcement area, is we do actually have a ballot initiative in Wyoming. In Wyoming right now, only cannabidiol is legal as hemp extract, so with a very low THC content. So that has really not become an important market in Wyoming. It's a medicinal use for seizure disorders. And that law is new. That was passed in 2015. So we have very little experience with legalized marijuana or cannabinoids. Now, what we do have is a ballot initiative. And it's a little interesting. It has not gone on the ballot because the petitioners did not get 30,000 signatures or so to get on the ballot this year, and they were not able to collect enough signatures to legalize marijuana. It's not for recreational use, it's a medicinal use, but it's one of those medicinal laws that, like Colorado's first medicinal law, which was very, very liberal, and where 18-year-olds can claim they have fibromyalgia and get a certificate from the doctor, and they're down the street getting their medicinal marijuana. Our ballot initiative is very liberal in terms of all the physical conditions that could lead to receiving marijuana legally in Wyoming. But we don't know. It's not on the ballot this time. It could potentially get on the ballot in 2018. The signatures would have to be collected by 2017, February of 2017. So it may not make it on the ballot. But if it does, I think there are some problems with it that I think may be problematic for it becoming voted on by a majority of the voters. I think the biggest one is the fact that there is no local opt-in or opt-out. And Wyoming has a pretty strong tradition of people of local communities, whether it's in education or other areas, believing in local control. And I think the Wyoming voters may have some difficulty accepting imposition of marijuana in every community in the state and not having an opt-out. So I think that might be a fatal flaw in this ballot initiative. But anyway, because there's a ballot initiative, Governor Meade did appoint a commission, and we spent a lot of time, many meetings, and a lot of work led by some excellent professors at the University of Wyoming, and produced a 247-page report that actually has some very good information about various issues, policy issues, probably more than some legal issues, but policy issues about legalization in various places, and talking about the various models, the liberal models versus, for example, Vermont's very restricted model of medical legalization. What do I see as some coming issues, some challenges that we face? And I think I'll mention first, I think there's some difficult scientific issues that are going to be faced. They're faced to some extent whether marijuana is legal or not. But in the law enforcement area, we have a problem, for example, in Wyoming, where we have a statute that says that a certain amount of plant material in possession is felony possession over a certain amount, also in liquid form. Well, we don't have one that deals with brownies. And we have a recent district court decision. It's not a Wyoming Supreme Court decision, but we have a recent district court decision that the law does not restrict the quantity of having brownies. This fellow had brownies, cookies, and chocolate. He had all kinds of stuff when he got caught, but it was not. So that hasn't gone to the Wyoming Supreme Court. But so we have legal issues in terms of what is it. Marijuana in brownies is, it's extracted into oil, and then the oil is used in cooking, I guess. That's what I'm told. And so is that a liquid? Is that a solid? What is it? So we have some issues like that, just labeling issues, I guess. We have quantification issues. You know, it's more difficult to figure out quantities of marijuana. We have in our crime lab gas chromatograph technology. Well, to really find out quantities of marijuana without changing the quantity of THC, and that's what you want to know. You want to know how much THC is in the sample. In order to do that, if you use a gas chromatograph, you have to basically, you know, oxidize the material. You burn the material. Well, that creates more THC from THC acid. Well, now you've disrupted your sample. You can't necessarily tell what the quantity is. So in order to do this, you have to buy other equipment. You have to buy, you know, liquid chromatographs. They're very expensive, and you have to change your protocols on how you do it. There's another issue that comes up in that area, and that is how do you get material to calibrate your equipment? We know that, you know, for example, we go to the gas station, and at the gas station we know that there are inspectors that go around and make sure that the flow coming out of the gas pump is the right amount of gasoline, so we're not being cheated by the gas station. Well, they also have to calibrate equipment in a crime laboratory. So to calibrate that equipment, you have to have samples of the material, and you have to obtain it legally through the US mail somehow from a lab that says this is how much THC there is in our calibration material. Please calibrate your equipment using this material. Well, that THC in the sample degrades over time. So you have to have continued shipments of calibration material, and of course you have to buy it. And where's that going to come from? Well, there's a lab in Mississippi where there's been some of that work has been done, but that's going to be an issue for crime labs and for other laboratories. What are the quantities? And what I found out doing some research for this panel, there's a Journal of American Medical Association article about medicinal marijuana, and they did a study, it's a recent study, 2015, in Seattle and in Los Angeles involving medical marijuana and looking at the dosages that were put on the packages. And the dosages were wildly inaccurate. There was only less than 25% of the dosages on the labeling on the packages were within 10% accuracy of the amount of THC in the sample. So there are significant scientific issues in just going about regulating marijuana and regulating THC contents. And I think what we're seeing, what the statistics are showing, and we're seeing it in Wyoming in terms of what's being seen trafficked into the state, is that the direction of marijuana use is in the direction of edibles. That seems to be where it's going, and that seems to be where some of the biggest scientific challenges are in edibles. There might be an increase then in also vaping instead of, you know, smoking joints, but actually vaping. So that's going to be a challenge for legalization, is this edible issue, and we're seeing that already. A couple quick points. I don't want to take everybody else's time. From my perspective, we have kept statistics over the last several years. Wyoming did not join the suit by Nebraska and Oklahoma against Colorado on you know, the federalism case, but we did engage in begin taking statistics about spillover, you know, into Wyoming of marijuana that's purchased legally in Colorado. Well, I shouldn't say legally, but at least under state law, that's purchased in Colorado and then makes its way into Wyoming. And what we found is, and these statistics I think are pretty reliable, is that there's been a pretty significant increase in terms of the amount of marijuana in Wyoming coming from Colorado, legal products. I mean, it's pretty easy to tell. They're in packages with labels. We know where they came from. We have all the labels, so we know where they came from. I'll throw a couple of quick statistics at you. Marijuana incident reports from 2014, 127 of 881 were from Colorado. The next year, 2015, it was up from 127 to 156 out of a total number of incidents that were down by 100. So in 2014, 127 of 881, and in 2015, 156 of 783. So a very significant percentage increase of were coming from marijuana that was purchased in Colorado. Also, we've seen the largest increase in some parts of Wyoming. The amount of marijuana incidents have gone down in the last 5 years in northern and northwestern Wyoming, but in southern Wyoming, which is on the Colorado border, we've seen a large increase. So it's pretty clear, the evidence is pretty clear that being a neighboring state, that we have more marijuana coming into our state from Colorado, much of it purchased from legal dispensaries in Colorado than we've had in the past. So it does have an impact on a neighboring state, and I don't think that's all that debatable, actually. But let me just close. I think I've been around long enough, and turns out my father was a school principal in Pennsylvania back in the 1960s and 70s, and in those days marijuana was debated, of course, and also there was big issues in those days about smoking and cigarette smoking, and we had in those days, it's hard to believe now, but there was a time there when all the schools, high schools in Pennsylvania, started allowing smoking in the school, but not in the classroom. They had special smoking areas. And so everybody thought the wave of the future was pretty soon everybody would be smoking in the classroom. So trends don't always go in the same direction. I mean, today nobody would think of having smoking areas at schools. So, and I think the same thing actually happened with marijuana. There was a period in the 70s when there seemed to be momentum towards legalization, and then it went the other way. But then now the momentum has shifted back again. So in these areas of substances, you have ebbs and flows in the public thinking about these things, and I wouldn't be surprised if we don't know what the next ebbs and flows are going to be in the marijuana area. And I guess finally, let me just say one last thing, which is in preparing for this and also in doing our report for the state, for Governor Meade on marijuana legalization, one of the things that's so striking about marijuana, for example, compared to what we know about tobacco today, is the long-term effects. The medical knowledge, at least what I've seen, is not that good about what the long-term effects are on, for example, heavy use by people that start using marijuana, in their teens. And so I don't think that the last word's been spoken. Of course, that issue is affected by whether marijuana has been available to do clinical trials and long-term studies with, and it hasn't been in a legal form. So it has been in Europe, obviously, but I think there's really a dearth of knowledge out there still scientifically about the long-term effects of marijuana on health. And so, for example, the attorneys general of the United States have a huge effort, education effort to reduce youth use of tobacco, and it's being very successful. The amount of kids starting tobacco use in their teens is going down dramatically in the country. And yet here we have the opposite phenomenon. I know Colorado's, I guess they can hold up their finger and say we're #1 because they are now #1 in marijuana use among, I think, all demographics. These things ebb and flow over time if you take the long view. But appreciate your time, and I hope maybe I've thrown a few ideas out that might be of interest to you.
Thank you, General Michael. Well, like it or not, it is legal in Colorado, at least at the state level. General Yarger, what are the challenges that you and your office face in representing and enforcing state marijuana law?
Well, I think General Michael was right that you kind of have to understand where a person comes in terms of their perspective to the debate. And I'm kind of lucky in that regard. With all the controversy and difficult issues that surround marijuana, I get to put that aside and represent the state in some very important and terribly fascinating legal issues, at least if you're a legal nerd like me. And so the perspective I bring to it and the challenges that I've faced are wrestling with questions of preemption. Everybody knows that when you walk into a marijuana store in Colorado, you're breaking federal law and you're becoming a felon. At least you could be prosecuted as a felon. And what do you do with that? And what's remarkable is, despite 20 years of legalized marijuana in a very significant way, starting with California, the law on preemption is pretty unclear. Courts can't even agree what method of preemption to use, and they've only scratched the surface of the preemption provision that's in the Controlled Substances Act. So we don't know if the standard we apply is an obstacle preemption standard, which kind of measures the effects of the law and how it operates in practice against the goals of the Controlled Substances Act, or if it's a much narrower version of impossibility preemption, where if there's a way for someone to comply with both, there is no preemption. And so we wrestle with that. We've been obviously defending a number of lawsuits on the preemption front, so far successfully. But as these progress, we still don't get much by way of clarity on the law, because most of these cases have been kicked on standing issues or on preliminary issues about whether or not somebody has the ability to step into the shoes of the federal government and enforce the Controlled Substances Act. And the only other point I'd add, Judge, before I turn it back over is how interesting it is that the federal government is of multiple minds about this. We have the enforcement guidance, which presumably tells us what we have to do to stay in the federal government's good graces and continue regulation. But we don't know how they view those enforcement priorities and what they look at to determine whether or not those enforcement priorities are being met. We don't know how they would go about enforcing against a state that they believe are not holding up their end of the bargain in terms of those priorities. They could use the blunt instrument, presumably, of a preemption lawsuit to get rid of all of our laws on the subject. And in fact, in letters to the state of Colorado and the state of Washington, General Holder preserved that option and said that they won't seek to enforce the preemption provision against the state of Colorado, at least not at this time. And here we are 4 years later, heavily into commercialized and regulated recreational marijuana. And so the other option is they could enforce on an individual criminal prosecution basis. That doesn't seem satisfactory either, because it doesn't get at the root of the problem, which would presumably be with a state's regulatory framework. Now, the other side of the coin is Congress, and Congress has been both broader and narrower in how it's approached the problem. Broader in the sense that the spending legislation doesn't look at enforcement priorities. It just says, as long as someone is in compliance, DOJ, you can't spend any money on a prosecution or doing anything to interrupt the state's regulatory process. But it's narrower in the sense that it only covers medical marijuana. And oddly about that, we know that from cases like Oakland Cannabis in the U.S. Supreme Court and Raich, it doesn't matter what you're doing with marijuana. It's a Schedule I substance, and it's illegal under the Controlled Substances Act. So I think Professor Kamen is right. It's a truce. The outlines of those truces have been drawn, but the very specific ways they might play out if we had situations where those outlines were tested are not entirely clear. And so far, it's really been up to the states to regulate, to the best of their ability, keeping in mind the will of the people and the laws that they've put in our Constitution, to implement a regulatory structure that survives challenges like the ones that we're litigating against.
Before I turn to Oklahoma, Fred, is Colorado seeing any sort of empirical effect on law enforcement? Has there been an increase or decrease in crime activity related to drug trafficking? And have you seen any impact on the social services? And I'll turn that to the other panelists too in a minute, but I wanted to start with your perspective from the Colorado Attorney General's office.
Well, I am not as heavily involved in the social services aspect or the criminal enforcement aspect. I get to keep my head up in the clouds in all the preemption stuff. I can say that we've had some major law enforcement initiatives coordinated by this office, by my office, prosecuting individuals that were attempting to use the state, particularly the medical laws, as shields to cover up interstate trafficking. And those stories certainly catch headlines. What's difficult for me to opine on is at a very granular level how you measure whether or not the legalization is increasing use from a baseline that might have been hard to measure before. Certainly the numbers that we're getting from the federal government, the Rocky Mountain high-intensity drug trafficking area, which covers the corridor in the Rocky Mountains, suggests that there's an increase, suggests there's an increase in cross-border trafficking. So I think there are certainly some compelling arguments that that's a side effect and certainly not an unanticipated one. But I don't know if I have enough information to really speculate about how accurate that is or how that plays out.
Let's turn to Oklahoma. Mr. Mansankani, Oklahoma sued Colorado. Tell us about that.
Well, you know, it's in a little bit of an awkward situation, surrounded by Coloradans, and the suit is originally brought in the U.S. Supreme Court, and the U.S. Supreme Court has original jurisdiction over suits between states, but they have interpreted that jurisdiction to say it's discretionary and they can decide whether or not to even hear the case, much less its merits or standing cause of action. And in this case, they decided that no, they were going to exercise their original jurisdiction, and so now we're left to have intervened in the 10th Circuit right now, re-alleging our preemption claims. I do want to talk about what General Michael already sort of covered, which is the effects on states that border Colorado, but then I'll get to the bigger issues about what marijuana, recreational marijuana legalization, or authorization, if you want to call it. Legalization is sort of a weird term because it's still illegal. What that means for the nature of our federal system and our constitutional order. You know, as far as the effects from a bordering state, we know, and I think everybody recognizes, that interstate trafficking is a reality, and a reality that's increasing. In 2014, and 2014 was one of the first years of recreational legalization in marijuana, we had several thousand pounds go to 36 different states coming from Colorado, and I'm sure that number has increased even more in 2015 and 2016. And there are not a lot of mechanisms that are in place to prevent sort of known drug dealers from other states to come into Colorado and buy marijuana, or known felons in other respects. So, you know, we had a case in Oklahoma where a known sex offender went from Oklahoma to Colorado, bought marijuana, and came back to Oklahoma and was caught trying to sell it near a school. But in addition to the trafficking outside of Colorado, it's also true that there's lots and lots of people coming into Colorado as tourists to participate in the marijuana market. The retail demand from marijuana in Colorado is actually primarily driven by visitors and not from people in state. And surveys show that as many as half of the visitors to Colorado are motivated in part to visit because of marijuana, but I'm sure that the attendees of this conference are an exception to that statistic. And if you look at a map of the dispensaries in Colorado, and Professor Mikos gave a somewhat old one from 2014, but I think if you look at a newer one, you'll notice that the concentrations of dispensaries in Colorado are in two areas. One, which you would expect is major metropolitan areas, and the other is all along the Colorado borders, with Kansas and Oklahoma and New Mexico and Wyoming and Utah. And this flow of marijuana into other states, as Fred said, is not a surprising result whatsoever. We would expect it to naturally occur. Interstate trafficking is the inevitable and entirely foreseeable consequence of a state authorizing the industrialization of marijuana, no less unpredictable than if a state dumped pollutants into air and rivers and it flowed into other states. So I was on a flight here from Oklahoma City, and I was explaining these things to the lady sitting next to me, because she asked me, well, what are you going to be speaking about in this conference? And she furrowed her brow and she asked me, well, don't you think there should be some, I don't know, federal policy coordinating drug laws so all these differences between states don't cause problems? And I looked at her and I smiled and said, well, ma'am, whether there should be such a nationwide policy or not, I don't know, but the reality of the matter is there already is. And at this point, it dawned on her that, yes, many years ago, Congress passed a law making marijuana illegal nationwide, and that law has never changed. But now we sit at a very odd time in history where states are beginning to pursue their own policies regarding marijuana, as if the Federal Controlled Substances Act didn't really exist. Indeed, I can't think of another situation analogous to the current status quo on marijuana, either now or any time in history since the nullification days before the Civil War, where federal law completely prohibits an activity, and yet individual states enact and enforce laws affirmatively authorizing that activity in a manner that causes its proliferation and imposes externalities on other states. And I think this unique situation creates novel legal issues about federalism, the nature of our union, and the role of our federal courts that we all have to wrestle with. So although marijuana is a subject du jour that raises this question, much larger issues and profound questions than marijuana policy are at stake. One approach to looking at this issue is to consider the purpose of the Constitution's Supremacy Clause and the problems it sought to rectify, as well as the purposes of the federal courts established by the Constitution. We start with the premise that, as sovereigns in our constitutional system, states have the ability to set their own policy to address the social ills that confront their communities. But certain problems of public policy are inherently interstate in nature, and for those problems, the Constitution provides a solution. The states' representatives in Congress can all get together and they can vote to pass a law to set national policy on the interstate issue, agreeing to give up a measure of their own sovereignty in favor of a uniform system. But what happens when a state attempts to go back on that bargain by implementing a different policy, thereby imposing externalities on other states? Alexander Hamilton in Federalist number 15 said that the lack of the ability to solve this particular collective action problem was, quote, the great and radical vice of the Articles of Confederation. Hamilton said under the Articles of Confederation, the problem was that these national laws, though in theory were laws, yet in practice they are mere recommendations which the states observe or disregard at their option. The framers created the solution to this problem in the Supremacy Clause, which acts as a negative to conflicting state law, and in the creation of the federal courts, which act as neutral adjudicators to enforce the Supremacy Clause. Without such mechanisms, Madison noted that the Constitution would have been evidently and radically defective, and Hamilton said that it would have amounted to a mere treaty dependent on the good faith of the parties and not a government. So when we speak of federalism, we don't use it as merely a code for a blind pursuit of states' rights, but rather as a way to seek application of the Constitution's balance of power between the states and the federal government. And to be sure, in recent years, it's been more often than not the federal government which has been exceeding those bounds, but we must not lose sight of the fact that federalism was meant to restrict states in certain instances as well. I think it's useful to have this view of our federal system in mind when we think about the legal and structural implications of the Controlled Substances Act and recent state efforts to authorize marijuana production, commercialization, and use. Through the CSA, the states' representatives in Congress got together and agreed to ban marijuana for all uses nationwide because it determined that marijuana is, 1, a substance injurious to the public's health, and 2, heavily trafficked between the states. It was an interstate problem that states agreed needed a national solution. And this agreement in Congress included, by the way, the entirety of the Colorado delegation. The CSA contains explicit legislative findings that say that the control of local possession, growth, and distribution of controlled substances was necessary to control the interstate trafficking of drugs. And so in the Supreme Court's decision in Gonzalez v. Raich, it was premised on the idea that the CSA could constitutionally prohibit these intrastate activities because any significant exemption in the marijuana market would undermine the CSA's ban on interstate trafficking. But now certain states have chosen to renege on that bargain by taking affirmative steps to create a marijuana market for the express purpose of profiting off of that billion-dollar industry now. And all the while, the marijuana is being trafficked to other states, causing precisely the type of harm the states through Congress were trying to prevent. And it can hardly be said that what's taking place on the ground here in Colorado and other states is what Congress intended to happen when it enacted a near complete and total nationwide ban of every aspect of the marijuana trade. I think this creates a singular situation in American law where there exists an unresolved tension between federal law and state law, both enjoying irreconcilable coexistence for the time being. And this leaves federal courts, I think, with a host of questions to answer. Can state law grant licenses to perform an activity that is unlawful under federal law? Can a state create a regulatory structure to facilitate a market made illegal by existing federal statute? Can a state create a property interest in federal contraband? Can a state profit off the activities through tax revenue, as Colorado did to, I think, $135 million in 2015, even though those activities are banned by federal statute? And if the federal executive branch decides to acquiesce to such state activity, can other states seek to preserve the union under federal law and vindicate the national policy from which those states once enjoyed the benefit? Of course, there are well-established ways to change national policy. The CSA could be repealed in whole or in part. Or courts may decide that Gonzalez v. Raich was wrongly decided and it's unconstitutional for Congress to regulate local marijuana growth and consumption. Or marijuana could be reclassified as no longer a Schedule I substance, which the DEA decided last month not to do. But the question posed now is, can the CSA be dismantled by piecemeal nullification as state after state decides to depart from the national legal policy? And other attendant legal issues emerge as well, as Professor Kamen pointed out. Because the prohibition of marijuana has been national policy for so long, an entire legal structure has been erected based on the presumption that marijuana is by law illicit. So if the tension between state and federal law is to remain, many other vexing legal questions arise, as Professor Kamen pointed out, in banking, in taxation, in employment, in legal ethics. You can add to that in firearms. In order to purchase a firearm, you have to go and fill out a form that asks you, do you use illicit drugs? And if you say yes, you can't get that firearm. In housing and public benefits, you generally can't use federally illegal drugs in public housing, which causes sort of a different impact on people who are dependent on federal benefits. So this is just a sampling of the many questions that the federal judiciary will be forced to confront if the status quo on the coexistence of these conflicting state and federal laws is allowed to remain. Of course, none of these questions pose much of a problem if the larger question, whether our constitutional structure permits a state to affirmatively authorize and license activity prohibited by federal law, is answered in the negative. So it is that question about the nature of our federal system, which I think is both the most interesting and the most pressing question of the legal issues surrounding marijuana that confront the federal courts today.
Well, that proves why this is the dream issue for our academics up here. And I'd like our two professors actually to react some to what they've heard from the other speakers. And in particular, I'd appreciate your comments on this externality issue, whether it's drug trafficking to other states, a rise in crime, if that's true, or what the data show in Colorado, and maybe some other externalities on social services, such as growth in homelessness, if there's any data that would support that. But what's been the consequences of this, this new big market?
Well, maybe I can jump in on the externality point. I think there's a valid point that's been made. I think certainly if Colorado or any other state legalizes marijuana, it's going to have effects outside that state. And that is the classic collective action problem. But there's a proper way to deal with that. In the past, what Congress has done is it's essentially free-rided off of state law enforcement. State law enforcement historically has handled 90, maybe even more than 90% of marijuana cases. Congress benefited from that. Neighboring states benefited from that when Colorado was policing its prior prohibitions. Now, Colorado and other states have no obligation to continue doing that, any more than Oklahoma or Wyoming have an obligation to expand Medicaid or to ban firearms that the federal government prohibits, but state law does not. The proper way for Congress to deal with that is to pass new legislation, maybe new spending legislation that would ramp up federal enforcement. You can't force a state to go out there and police marijuana, but nothing the states have done would prevent Congress from stepping in and hiring thousands more DEA agents to try to replace the work that the states used to do gratis for the federal government.
Well, incidentally, before you begin your comments, I would like to take some questions from the audience. I know you're here because you're interested in the topic. So after we wrap this up, we do have some mics in the room, so you can feel free to ask some questions.
Well, thank you for that. I'm not surprised. I agree with my friend Rob on this. You know, you mentioned that the CSA can't be dismantled by piecemeal legalization in the states. The CSA is still the law of the land. The reason that people are operating grow facilities and dispensaries in Colorado is because the national law enforcement agencies have chosen not to enforce the Controlled Substances Act, and the national legislature has said that enforcement cannot take place against medical marijuana dispensaries. So the federal government has the power and capacity to end this experiment whenever it chooses. The reason it is not done so is, I think, a policy decision that these experiments in the states should be allowed to continue. And I would sort of second what Rob said, which is the states are under no obligation to enforce federal law. They are under no obligation to pass prohibition under their own state laws, and they're under no obligation to leave those prohibitions in place. The thing we're really arguing about is, as the Oklahoma and Nebraska briefs to the Supreme Court indicated, the only thing we're arguing about is the regulatory and tax regime that states like ours and other have put into place. And the question is, would Oklahoma and Nebraska be better off if those were dismantled? I think the answer to that is almost certainly no, that if marijuana were legal but not regulated in Colorado, I think that would have far more negative repercussions for Oklahoma or Wyoming or Nebraska or Kansas than our current regime. As to your question about measurement, measurement is really hard in this area. So for example, one of the things that we hear is that impaired driving arrests have gone up in Colorado, and I have no reason to doubt that that's true. But it's important to remember that Colorado patrol agents are being trained now, more than they were before, to identify instances of impaired driving attributable to marijuana. So in much the same way that the increased awareness of sexual assault during the 1980s might have been seen to lead to less sexual assault. In fact, the arrest rates went up because law enforcement was taking that more seriously as a concern, and you saw more willingness on the part of law enforcement to take seriously those complaints and to prosecute them. I think we're seeing something similar with regard to measurement in this context.
We're going to get a new Attorney General, U.S. Attorney General in January, in all likelihood. What do you think the consequences would be of Attorney General that made enforcement a priority and withdrew some of the policy guidance that the state is operating under now?
I think that is a question of political will and not one of law. Clearly, the Attorney General has the authority and responsibility to enforce federal law throughout the country. The current Attorney General and her predecessor have taken the position that there should be deference. There's nothing to prevent other than Section 542, which applies only to medical marijuana. There's nothing to prevent a new Attorney General from changing policy, and Attorney General Chris Christie might do something very similar. He has said to Colorado when he was campaigning here, smoke them if you got them, because when I'm president, it's going to go away.
Questions from the audience? Yes, sir.
In Colorado, we've got 300 banks that can't take cash from the marijuana business. In Colorado, we've got 300 banks, maybe a little more, that can't take cash from the marijuana business, and yet the state takes its revenues that it receives from the marijuana business and puts it in the bank. I mean, I understand the legal labyrinth that we're talking about, but based on just finances, isn't the horse out of the barn on this? Isn't this going to be driven by finance and market concerns, and the law is going to be?
Well, I don't know if that was directed at me. I think, look, I think you see.
It wasn't directed at you.
Part of the reason that Amendment 64 was enacted, and it's in its preamble, is in the view of the people, it was a wise use of state resources to deal with this issue in this way. Certainly, tax revenue was a significant part of that. The bargain was we take a industry that's thriving in the shadows, we bring it into a regulated framework, and we take a slice of that like we would any legitimate business. And I think apparently that public policy argument has been resonating, and I think it'll continue to expand. What I look forward to as a lawyer is when California finally legalizes recreational marijuana, as I think it might decide to do this year. It had tested the waters in some ballot initiatives before Colorado took that step. And once the 6th largest economy in the entire world becomes a recreational state, I think it will be difficult as a legal, as a practical, and as a financial matter to do what Governor Christie suggested he might do had he made it through the primaries, which is change course after really now we've got 5 years, or it's longer than that, almost coming up on a decade since the '09 memo, and since Colorado and other states have begun commercialized, regulated supply chains for marijuana. I don't understand how you can cleanly walk back to that and go back to 1995 before states started going down this path. The other point I did want to add, which I think is very fascinating about the way the CSA operates, and in a bit of a response to Deputy Solicitor Oklahoma's comments and Professor Kamen's comments is that the CSA is commerce legislation. And what that means is that the CSA operates against individual people. It doesn't operate against the states. So in other regulatory frameworks, in Medicaid, for example, there are clashes between the states and the federal government all the time about what the laws mean and how they should be implemented and whether or not the states are living up to their end of the bargain. That's just simply not how the CSA works. The CSA says, federal government, we will create crimes that you may enforce. States may cooperate with the federal government. In certain circumstances, very narrow ones, they can enforce the CSA. But that's probably why we haven't seen so much case law on the preemption issue, and why it hasn't been fleshed out the way it is, say, in the Medicaid context, where you've got constant interactions on that dimension with the state of the law. So it's a fascinating area. I don't necessarily agree that the way it has played out is sort of contrary to notions of federalism. Congress has immense tools to tamp down federalism when it wishes to. It has huge budgetary muscle to wield against states when it wants states to do certain things, and we face that all the time as state officials. The CSA just simply is a very different kind of legislation, and that's frankly why I think we see this fascinating, unresolved body of issues that Oklahoma was pointing out, which I look forward to their resolution, one way or the other.
Yes, sir.
The Controlled Substances Act is the legislation that results in the scheduling of drugs, right? And since 1992, I think Professor Michael said the physicians in various states have had some kind of authority to recommend or the use of marijuana for individuals. Has the Drug Enforcement Agency thought about the rescheduling of the drug in the context of a variety of physicians throughout the nation recommending it contrary to the DEA's scheduling of it?
Professor Michaels, also Sam.
Yeah, I'll try to be quick. So there have been at least three instances over the last 20 years where the DEA has revisited the scheduling question. It has authority under the Controlled Substances Act to move marijuana to a different schedule. On each of those occasions, including just a few weeks ago, the DEA refused to move marijuana. And I think the main reason is that the main difference between the DEA's view of the drug and the state's, medical marijuana state's view of the drug, is that the DEA requires a different type of evidence. It doesn't want anecdotal evidence, doesn't want practices by physicians. It actually wants to see large-scale research studying the effects of this drug and demonstrating the medical benefits of this drug. And even though there's been a lot of research done on marijuana in the last 20 years, a lot of reforms to state laws, there hasn't been anything that's done, any scientific research that's met the sort of gold standard that the DEA requires. So it's a constant refrain from the DEA. Show us studies, don't just show us anecdotes and practices from physicians.
Sam, you want
And yet was its placement upon the schedule based on large-scale gold standard double-blind certain testing?
Go ahead, Sam.
I think the DEA has said that they have moved away from harm as a justification for Schedule I status and have focused on medical use. Just a couple very quick things. Rob mentioned we want sort of double-blind studies that show the benefits of marijuana. That's actually more possible now that the DEA has said that they will make marijuana, they will increase the number of licenses for people that want to grow marijuana for the purposes of engaging in that. Furthermore, I'll say that the refusal of the DEA to reschedule marijuana has consistently been upheld by appellate courts that have looked at it, whether it's in D.C. or in the Ninth Circuit. And the final thing, it was a small point, but you said since 1992, physicians have had the opportunity to recommend marijuana to their patients. That opportunity actually comes from the First Amendment and not from the act of any state, and that's what the Ninth Circuit held in the Conant decision, was that a physician cannot be precluded from recommending what she believes is a beneficial course of action to her client, and it borrowed in that context from a number of abortion cases, which said the doctors couldn't be prohibited from recommending that for their patients.
Please join me in thanking our panel for